Okay, we're now open to the public. Welcome members to the 57th meeting of the Committee for Finance in the 22 to 27 mandate members. As always, this meeting will be online and throughout Parliament buildings. Usual rules apply to those with mobiles. Item 1 is apologies. We have a couple of potential late attenders. We have 3 members, Jerry, Deirdre and Gemma, joining us on Zoom. And as I say, Philip Brett may be slightly late due to an appointment. Okay, agenda item 2, declaration of interests. Members are obliged to declare any relevant financial or other interests at each committee meeting. Has anyone an interest to declare? Diane?
Yeah, thank you, Chair. Just to declare, I also sit on the audit committee, and some of this legislative scrutiny is a wee bit back and forth between the committees, but I'll address it when it comes up.
Okay, thank you very much. Agenda item 3, chairperson's business. I don't have any chairperson's business today. Agenda item 4 is draft minutes of the meeting we held last week on the 10th of September. If members are content that those minutes are a true reflection of that meeting, I will sign them. Unless there's any amendments? No? Okay, agreed. I'll sign those. Now, agenda item 5 is matters arising. And the first matter arising is at page 30 of your pack. And it is the it's a briefing paper on the July outturn and forecast outturn documents. So that, as I say, is on page 30 of your packs. The Department has provided a briefing paper on the 25-26 outturn and forecast outturn expenditure returns for July. Departmental returns were made on the 8th of August. As members will recall, we are scheduled to receive an oral briefing on the June, July and August data at our meeting on the 1st of October, i.e. a fortnight today. So this briefing is largely for noting, unless anybody wishes to raise a particular point about it. Steve Aiken.
So, quick one, sir. Chair, in pursuant to your question you asked or the point of order you raised in the Assembly the other day about the FTC issue.
Yes.
I just want, part of, I think when the officials come to talk to us, I would probably like a greater explanation of that FTC, because I thought I understood it, and then after your question, I don't understand it, and reading through the documentation, I definitely don't understand it.
Well, my commentary FTC was about a very specific statement made, which I think inadvertently contradicts the final outturn for 24-25, which explained that there was an FTC, financial transactions capital, underspend in the last financial year. That obviously underspend is treated differently than a conventional underspend would be, but it was an underspend. So I was just clarifying that, but obviously we'll hear back on that. But yeah, we can ask the officials when they come to us if others are content. Okay. So the next matter arising is publication of NI departmental expenditure web pages. That's page 74 of the pack. The department has informed us of a new web page setting out NI executive spending over the period 2016 to 17 to 24-25. NISRA has developed these statistics to provide greater transparency on the spending of NI executive departments, and the department indicates this work also aligns closely with the work of the Northern Ireland Fiscal Council, which seeks to bring greater transparency and scrutiny to our public finances. We know we're scrutinising the bill that will put it in a statutory footing. The Fiscal Council has been engaged in producing this. I think this is actually useful. It is it's obviously NISRA. I think it will hopefully bring some more clarity to the public discussion on our spending and on our fiscal position. And I think there's already been some interesting commentary on it, including the kind of time series. I think it'll help us contextualise the conversation and explain to the public some of what is said. There are often claims made by us up here, both in the executive and outside the executive, and also the UK government. The more I think we have information which is produced separately or as it were independently, the better for our debate. So to leave it at that, unless anybody wishes to say anything. I'm sure we'll be able to interrogate officials and ministers about this about
Maybe
this.
through the chair,
Go ahead, yeah.
maybe we should just say that from this committee we welcome it, and it's part of greater transparency and openness, which is something that is to be welcomed.
If anybody has any concerns, I think that's that is a true statement. I mean, I think one of the comments, some of the commentary has been along the lines that the 16-17 to 24-25 spending chart, which was widely shared in social media, illustrates that Stormont has had increased spending power, which is true. It doesn't entirely account for inflation at all. It just has raw cash numbers, but I still think it's useful. Okay, so we'll move on. Members are content with that. Next agenda item is Audit Committee budgets for 26 to 29/30. The Northern Ireland Audit Office, for the Audit Office and also for the Public Service Ombudsman. That's at page 76 and 88 of the meeting pack. The committee has been copied into correspondence from the Audit Committee to the Minister of Finance, seeking the Department's view on the estimate for the Audit Office and NIPSO. Members will be aware of the role of the Assembly's Audit Committee in relation to both the Audit Office and NIPSO. The Audit Committee has asked for the Minister's view on both by the 18th of September. It should be, I think it's probably worth us saying that obviously we have the writ large responsibility on this, but it's not, we don't scrutinise directly these entities. That's the Audit Committee itself. Did you wish to come in on that, Gemma? Go ahead.
No sign.
Oh,
You're
sorry,
on
no, Chair. I
think she's
I'm on the audit committee as well.
All right.
Oh yes, you just decline your okay, no problem.
Right.
Thanks.
Okay.
Brand, does anybody else wish to come in on that? No?
Same.
Okay, with two declarations there from Diane and Gemma just on their membership of the Audit Committee. Now we're going to move into the tabled pack. 5.5 is similarly from the Audit Committee, and it relates to correspondence from them. We've been copied into correspondence from the Audit Committee to the Minister of Finance seeking views on the estimate to the NI Assembly. They've asked for it by the 18th of September. So anyway, this is really just a note. It's similar to the previous item. 5.6 is Cybersecurity and Resilience Network and Information Systems Bill. This is page 31 of the tabled pack, and this relates to a Westminster bill. The Department has updated the committee in relation to the Cybersecurity and Resilience Network and Information Systems Bill and associated legislative consent motion. Introduction has been pushed back, and it is understood that it will not happen this side of conference recess, which runs until the 13th of October. That's obviously Commons conference recess. The Department will update members as soon as it has more information. Members will recall last week's agreement that the committee staff make preparations for scrutiny of this bill, and I would just add that given our issues over the data use and access bill, it's very important that we're have early sight on proposed legislative consent memoranda and are doing our job and being seen to do our job properly on this one. Okay, that's to note. The next is from the Minister of Finance, and it also relates to another potential LCM. It's the Public Office Accountability Bill. That's at page 32 of the table pack. The Department has formally notified the committee that the Public Office Accountability Bill, known as the Hillsborough Law, was introduced to Parliament on the 16th of September. The Minister has indicated that he is not yet bringing forward a legislative consent memorandum before an assessment of the impact of the bill as introduced and the Executive's consideration given the cross-cutting nature of the bill. A detailed breakdown of the bill has also been provided with an indication of which parts will extend to Northern Ireland. The Minister has set out some next steps and indicates that further analysis and the views of the committee will inform how he will advise the Executive in respect of support for an LCM. The Clerk, did you want to update us on your discussions?
Chair, I met the departmental board in August and have subsequently written with updates based on guidance that's now been firmed up by both the Speaker's office and the Business Office. So I think we're in a good position to know how to approach this, but also reflecting the fact that the process is rarely perfect. There's rarely perfect information from Whitehall departments, so there are often a few bumps on the way. But I think with the discussions we've had and the use of Standing Order 42A in its fullness will probably allow us to make sure that the House has a lot more information. I would also suggest, Chair, that perhaps it might be worth the committee forwarding on the two memos to other stat committees. It may not always be relevant to them, but it does allow members more generally to have a heads up on these LCMs as we know them now and before they come.
Just so we're clear, at the minute, the finance minister had agreed, or the executive had agreed in principle, to consider whether to implement the duty of candour. So the duty of candour does not apply in Northern Ireland. It's not a UK-wide bill in that sense. They're considering whether it should.
There are elements of it that would fall into the devolved. So as it might be worth just kind of going back on, any kind of legislative consent process is engaged on a Westminster bill when there are aspects of that bill that will be legislating in devolved competences. Yes. So it's essentially a case of the minister and the executive making a decision as to whether or not they are content with that to happen on the basis of approval then from the House. Ultimately, it's the House that will decide, theoretically, that they are content that Westminster legislate on the Executive and House's behalf. So at the minute, these are early on process. So one has been introduced, the other is waiting to be introduced, and we're kind of going to get a lot more information by mid-October because the conference season in Westminster has kind of put a hold on everything. So this is a much earlier flag up than perhaps we've seen. It's much more information at a much earlier stage. And it will be for the minister to decide whether or not he wants to bring forward, well, in conjunction with executive colleagues, whether or not he wants to bring forward a legislative consent memorandum that would contain a draft motion. However, under Standing Order 42A 4B, a memorandum can be brought forward saying the minister is not necessarily in a position to be seeking legislative consent at the minute. However, here's what the bill does, here are the aspects of it that engage the devolved competence, and this is really just for the information of committee and members of the House, if that makes sense.
It does.
Good.
Just
one
thing through the chair. Of course, one of the issues one of the things we need to be aware of is sort of Article 2 compliance issues. So I mean, it's probably slightly more complex, and the earlier we see sight of it, probably the better. Yeah.
Yes. Okay. Okay. So we will get more on that hopefully soon. Now,
Chair, sorry, if members are
agreed that the committee will start
those.
planning.
Thank you.
The next is the schedule. It's from the department. It's the schedule of secondary legislation. That's at page 102 of the table pack. The department has now provided an indicative schedule of expected secondary legislation for members' information. This will be used to populate the forward work programme going forward to assist with planning. Members agreed that we will request the department update us on any changes. If they're agreed. 5.9 is from the Committee for the Economy and it relates to public procurement, SMEs, micro-businesses and social enterprises. That's at page 103 of the table pack. Following consideration of a Department of Economy research bulletin, including reference to procurement from SMEs, micro-businesses and social enterprise, the Economy Committee has written to the Department of Finance seeking an update on the publication of statistics showing the extent of public sector contracting to SMEs, micro-businesses and social enterprises, the location of the relevant businesses and further information on the impact of the changes made to the low-value tendering process. So members, that is to note pending a copy of the response from the Department. We're content. 5.10 is correspondence from Protective Mothers NI. That's at page 124 of the tabled pack. Protective Mothers NI has written to the committee to request an urgent meeting regarding financial misuse in the family court and safeguarding systems, financial decisions and failures in domestic abuse response and related matters. Members will recall similar correspondence considered at last week's meeting and the agreement to adhere to the committee's agreed approach to correspondence and not linked to strategic priorities or statutory duties, which is to advise correspondence that relevant departments are best placed to respond to their concerns. But we obviously are noting the correspondence for now and also indicating that we actually don't have any policy locus in these issues. Pardon me, that's not to say they're not important.
It is justice, and I think there's a communities element as well.
Okay. So now we are moving on to agenda item 6, which is the Death, Stillbirths and Baby Loss Bill, and we're considering our report. So we're going to go into we're not going to go into closed session yet. We are going to agree that Hansard, people are content that Hansard will record this. This is page 106 of the meeting pack. Members have been provided with a final copy of the report on the Deaths, Stillbirths and Baby Loss Bill following our discussions last week. The section on clause by clause consideration has been added, as I said, following last week's discussions. Any typographical or formatting errors will be amended to final proofing stage. So, members, it's in front of you. Does anybody have any final comments or suggested changes to the report? Content?
I'm content.
Okay. If there are no amendments, members, I'm now going to proceed through the various sections to get formal agreement. So, first, members, it's the title. Please turn to the. You can turn to the title page, contents page, powers, membership, and list of abbreviation and acronyms. Excuse me, I'm going to blow my nose. That's not part of the report, to be clear. I'm going to put the question: are members? Yes, that would actually spice things up a little bit in the report. Are members content the title page, contents page, committee powers, and membership pages stand part of the report? Content? Yeah.
Yep.
Executive summary. That's at paragraphs 1 to 11 of the report. Are members content that the executive summary section, paragraphs 1 to 11, stand part of the report? Content?
Agreed. Yep.
Introduction section, members, that's at paragraphs 12 to 16. Are members content that the introduction section, paragraphs 12 to 16, stand part of the report? Content? Agreed. Committee approach section, that's at page 17, paragraphs 17 to 28. Are members content that the committee approach section at 17 to 28 stand part of the bill? Content? Consideration of the bill section, that's at paragraphs 25 to 35. Are members content the consideration of the bill section at paragraphs 25 to 35 stand part of the report? Content? Clause by clause consideration of the bill.
29 to 35.
29 to 35, my apologies. That are people content that I should just I'll read that again so it's correct on the record? Are members content that consideration of the bill section at paragraphs 29 to 35 stand part of the report?
Agreed.
Okay,
Yeah.
agreed. Now, the clause by clause consideration of the bill section, that is at paragraphs 36 to 127. And that was the a lot of what we did last week. Our members...
Do we have to do them by... Are you quite happy just to do
the section? We'll be doing the section as a whole.
Yeah.
Are members content that the clause by clause consideration section at paragraphs 36 to 127 stand part of the report? Content?
Great, yeah.
Clause by clause scrutiny of the bill section, those are paragraphs 128 to 143. Are members content that the clause by clause consideration section at paragraphs 128 to 143 stand part of the report? Content? Content. Appendices. That's at page 141. Are members content that the appendices stand part of the report? Content?
Content.
And I'll put the question finally, that the report on the deaths, stillbirths and baby loss bill be the sixth report of the Committee for Finance.
Great.
Members, are you agreed that it will be laid in the business office and published on the committee web pages? In due course, agreed. Finally, members, obviously, I hope content that we send a copy of the report to the Minister of Finance in advance of the consideration stage of the bill. Agreed? Okay. Thank you very much, and thank you to the team who provided such sterling work on that report and all those who gave us evidence on it. Okay, members, just before we move on to the next three sections, there's an electronic bill folder on both the Administrative and Financial Provisions Bill and the NI Fiscal Council Bill. It was issued to members this morning, so it will be in your bill folder. It'll be a useful resource for this and future bill sessions. These folders will be kept up to date by committee staff, but combine all relevant papers on each bill in one electronic folder. Should any member or indeed their staff have any questions, they should contact the committee staff. Now, agenda item 7 is our briefing on the Administrative and Financial Provisions Bill from Assembly Research and Library Service. Members agreed that Hansard record and report this session. Hope so.
Right. Yep.
So, members, page 132 of the tabled pack, we have the research paper on this bill from Reyes, and obviously, I assume people are happy that it gets added to our evidence base and therefore on the committee web pages. We welcome Eileen Regan, who is senior officer at Reyes, and Eileen is going to give us a briefing. Hi, Eileen. Thanks for coming in.
Thank you.
Thank you. Please go ahead.
Thank you, committee. So today I'm here to speak to you about the bill paper that was prepared by a number of people in Reyes. I believe it's at page 132 of your tabled packs. And it addresses the Administration and Financial Provisions Bill. So looking at particular key considerations in terms of policy as well as public finance. And in the paper, we do identify some potential scrutiny points It's not an exhaustive list, obviously. Peppered throughout too, we have put a lot of hyperlinks for ease of access. So the committee is well familiar with these types of bills. They amend governing legislation and they regularize existing practice by prescribing departmental powers so that departments can undertake and charge for specified activities and modify existing financial governance arrangements. This bill, the executive agreed to it and the Minister of Finance brought it forward in June. It moved to second stage in early July and now it is in the committee. The bill, we understand so far, is based on engagement with various actors, including the Executive Office, OLC, the Office of Legislative, and the Assembly statutory committees. There's a number of departmental public consultations that have taken place in the summer of 2024 that also has informed the contents of the bill. A decision was taken that there would be no public consultation on the entirety of the bill, given its routine nature. So if you please, you can see in your pack there, at section 1 of the pack, pages 137 to 143, we cover what has happened in terms of what the key developments leading up to the bill and thereafter. They're there for your reference later on. I'm going to concentrate, given the interests of time, on the second section in the paper, which I understand starts at page 143 of your pack. There's a number of clauses to the bill. We're not going to concern ourselves with clauses 21 to 23, given their nature. They're about interpretation, commencement, and short title. The focus of the paper is on clauses 1 through 23, which respectively concern powers, fees, and financial governance. There's 17 new legislative powers created. They address administration and financial matters, and it's for a number of departments, which makes this bill slightly atypical than what they normally are like, given the scope of coverage.
Well, so just so I don't forget that point, it's atypical in what sense?
There's so many departments that where powers are enshrined, or if the bill is enacted as proposed. So, for example, Department for Infrastructure, Department for Economy, Department of Finance, etc. Whereas normally they're maybe not as wide-reaching, but the nature, it's technical matters, and it's also about the transference of powers.
Effectively, the number of departments whose activities are
impacted
is unusually large for one of these bills.
Yeah, I don't know if I would say unusually large, but definitely different. There are more than normally is traditional with these types of bills, generally speaking.
And just on that, the department did not undertake a consultation on the bill, basically because it's routine, but it hasn't happened in a while. It's a custom more honoured than the breach and the observance. What is, in previous instances, would they have done consultations?
No, not necessarily. But generally speaking, I think it's been about 11 years since we had a bill of this nature. So that also it's been a long time, and there's various reasons, including interrupted devolution will be a part of that. The committee, though, in that area, and learning more about this area of type of a bill, I guess, financial provisions bills, there is a report I would draw your attention to that it's December 2013. It's a report written by the former Committee for Finance and Personnel, which includes some very helpful information in understanding these types of bills more comprehensively. Okay, so we know that there's enabling powers to incur expenditure and to raise fees in this bill. At Appendix 2, which I understand is 187 to 189 of your packs, there's a high-level kind of ease of reference section so that you can maybe look at the paper alongside that to navigate, because there's a lot of, as you can see, the paper's quite comprehensive and long. Yes. I am going to concentrate on particular clauses where I think it would be very helpful for the Assembly, particularly the committee, to adduce more information, either to clarify or just to understand better what future plans are in terms of implementing the bill. If you look at your pack then, page 143, I draw your attention to clause 1. Clauses 1 to 14 specifically concern powers. This one concerns the financial transactions capital and the Northern Ireland Investment Fund, specifically that DOF would be empowered so that it could use FTC through the fund in order to invest in transformation concerning Northern Ireland in the long term, as well as support economic growth. FTC, as the committee will be well aware, has always been a chronic issue of underusage, and I draw your attention to a past paper raised prepared for yourselves dated March 2025, which would enable you to revisit the significance of FTC underspend in Northern Ireland. DOF maintains that this should help them to, when being empowered to issue loans to the Northern Ireland Investment Fund using FTC funding, that's financial transactions capital, and in doing so, it would have the statutory authority under this provision, and it would mark a departure from the existing arrangements where TEO, the Executive Office, and the Strategic Investment Board would be involved in the allocation of that funding. Drawing your attention to particular scrutiny points in that area, I think it would be helpful if the committee was able to learn a little bit more about any modelling that may have been undertaken by the executive or DOF in terms of how the DOF anticipates better future use in Northern Ireland under Clause 1. Also, it may be interesting, again, this may have more relevance in relation to Clause 2, but to see the potential implications. Has there been any kind of an assessment in relation to the role of Invest NI as a result of this clause, if it's enacted as introduced? And then this is a recurring theme. The bill's explanatory and financial memorandum says there wouldn't be financial implications, but many of the clauses do be given the powers that are coming in, the provision of services that are going to be permitted, as well as the funding that will follow. It does beg the question about the use of any new or additional resources in terms of training or maybe staffing that may be required in order to plan for the implementation of the clauses and then actually to implement. So the committee may wish to learn more about that. Scrutiny questions for Clause 1 are listed at page 146 of your packs. Moving on to Clause 2. Clause 2 concerns financial assistance and limited companies, and it empowers DFE, the Department for the Economy. This is an interesting provision because previously, before Invest NI, you would have had the department with the power to form limited companies. When Invest NI came about, that went away, but this is about reestablishing that power. And the argument was made that it potentially could reduce lead-in times. And again, Clause 2 potentially would enable better usage of FTC going forward, reducing the amount of money that would be returned to Treasury under the financial arrangements of current devolution.
Just on Clause 1, if I may, Eileen, and I know encouragement was generally would keep questions to the end, but I think if there's very particular questions. Clause 1 doesn't actually, we talk a lot about FTC and better use of FTC, both in general, and so that's one of the things that is stated to be the purpose of Clause 1. It doesn't say the bill doesn't say FTC in it, so it doesn't exclusively. It doesn't just say you may use FTC for these purposes. It just says you may lend funds for investment by an investment entity. Is there a reason for that, or would that be normal practice?
The committee could engage with the department about that to try and seek clarification.
Yeah. Interesting. I find it just interesting that they don't. I mean, it may well be sensible that they don't mention FTC, and therefore, because I guess the name of the thing might change. The UK government could change the name of the. But okay, that's it. Sorry, go on ahead.
No worries, thank you. Okay, then to go to clause 2.
Well, I might just actually bring Jerry. Did you? Because I asked a question, so I should be fair in that and bring yourself in.
Sure, I just had some questions for Eileen on clause 16 and 19, so I'm happy to wait.
Have to wait till then.
If you're happy enough until wait until then, that's great. Cheers, Jerry. Thanks. We'll come back to
16
you.
and
Okay. Sorry, Eileen.
No worries. So move into clause 2. Again, that's about financial assistance to limited companies, and it empowers the DFE to provide financial assistance using FTC in the form of grants, loans, guarantees, and indemnities, where the DFE believes it would be in the interests of the Northern Ireland economy. Such power departs from the current framework in that DFE would no longer have to go through TEO and the SIB, the Strategic Investment Board. Of interest in this clause also is what's highlighted in the EFM is that a statement of general approach or a guiding statement would underpin DFE's exercise of this power to ensure a degree of consistency and predictability. So the committee may wish to gain some understanding of that going forward. And as I said earlier, this is about reestablishing a past departmental power. So the implications for Invest NI might be something that they would like to learn about, the committee. Okay.
Go ahead, yeah. Thanks.
All right. I draw your attention to page 147.
Yeah.
Again, it's similar to the questions of clause 1 about modeling on future use and anything that could be learned in that regard. Learning more about this statement of general approach or a guiding statement. And again, any kind of an assessment that may have been done to learn about the role of NI going forward, given if this provision is enacted as introduced. And again, the question arises about additional resources and training that may arise and be needed.
Okay.
Is the committee happy if I move to clause 3? I'm not going to go through every clause, you'll be
No,
relieved to
no,
know,
very small.
but
Yes,
there are
sure.
ones in particular that are worth looking at. So clause 3 is about FTC loans in higher education. Again, there's very similar questions that arise in this context. It may be helpful, though, for the committee to look at what happens in Scotland and Wales. At page 148 of your pack, you can see that we've provided to give some very cursory overview of the arrangements there. Maybe just in terms of the operation of this clause if it's enacted. And what are the plans for the committee in terms of implementing this provision? So the committee may wish to ask about any modelling that may have been undertaken. I will move on to the next, if that's okay. Yeah. Clause 4, there's nothing particular of significance that we would raise. It's just similarly that question about the additional resources and training that might be required. And it's just to draw to your attention on page 150, there is an error, apologies. Scrutiny point 16 should not be there. It's just a typo. In the editing, we didn't catch it, so apologies about that. We'll make sure that the printed version doesn't include it. I'm not going to raise questions unless the committee would, or information or questions about clause 5. There's clause 5 concerns the visitor attraction experience grading schemes that would be empowered here. Tourism NI would have the power to classify and grade amenities for tourism Northern Ireland. There is a table that's rather comprehensive, so you can look across the jurisdictions to see what's happening there. But other than training and additional resources, there is nothing of particular significance that is being highlighted. Moving on to clause 6. 6 is about TEO being empowered to provide services and funding relating to victim and survivor support services and related funding for historical, institutional abuse and other forms of institutional harms. There's a number of things that we would want to draw to the attention of the committee here. One is that it empowers TEO to bring regulations in line with the requirements outlined in the clause. The regulations, it says, it proposes, would be going by negative resolution. That means basically they would come into operation automatically unless annulled by the Assembly within the given statutory time. We in RAISE believe this is important to highlight because negative resolution doesn't allow for the same scrutiny that would be given to a bill or even by other forms of procedure under the resolution mechanism. Again, the issues arise about financial implications in terms of additional resources and training. In the scrutiny points highlighted on page 160, they generally raise issues about the type of planning that has been undertaken, the communication that would be undertaken between the department and the Assembly, whether that be through the relevant statutory committee or other. What the plans are in terms of monitoring for the purposes of implementing clause 6. And they're all listed there on pages 160 to 161. Clause 7, if it's okay to go on to.
Yeah.
That concerns the provision of refugee and asylum seeker services and related funding. It's not about it empowering for the purposes of making any changes to the funding for asylum and immigration and support services. It's purely an administrative function that TEO would be provided so that they can make the expenditure. However, we do raise a couple of issues on page 162 about this. One concerns in terms of Northern Ireland's implementation of this provision. What would be done to assure the Assembly that TEO would work to protect against any divergence in relation to the definitions applied within this jurisdiction so that there would be an avoidance of any potential unintended exclusions or inconsistencies.
Can you say, I think there might be a slight wrinkle between the page number. I have that at page 157. But you have it at 162, I think. Eileen, so just maybe a slide so people are...
Is it more helpful than just to use the actual page number of the paper? Page 26.
Yeah, I think that's probably better. So that's 26, that's the
yeah.
page number of your paper. So people are looking at the raised paper. It's the page reference we're going to use now is the one at the bottom right rather than the top left, just because there might be a slight version control issue. But yes, great. So just on that, it's the upshot is... TEO currently has policy responsibility for refugee coordination and integration policy more generally, but it hasn't. It does have the VIRES for integration policy, and as sort of an adjunct to that, it's doing other things that it hasn't formally acquired some of the VIRES to do. Is that right?
Yeah, this is about the making of the expenditure. The legal authority to do that.
Some of that will have been happening within the black box thus far, I presume. Yeah. Yeah, okay, that's grand.
Okay. And again, in relation to clause 7, page 26 of the actual bill paper number, there's questions all about just the reassurance the Assembly may seek going forward in terms of the planning and the actual implementation of clause 7 if it's enacted as proposed, and monitoring then that and reporting to the Assembly that would occur thereafter. This committee may wish to seek assurances as appropriate in that way. Clause 8, we'll move on. Nothing in particular of note in relation to that, if that's okay with the committee.
Yeah, happy enough, yeah.
Moving on to clauses 9 and 10, this is a provision concerning victims and survivors and services and related funding provided to them. This relates back to the Programme for Government as well. It empowers TEO in terms of its 2024 strategic framework on ending violence against women and girls, and including powers that would help for the funding initiatives aligned to that framework's aims. Clause 10 is a qualification, I guess, on the exercise of Clause 9, and it specifies limits in terms of TEO's exercise of the powers in certain circumstances, and it specifies them where there's other pieces of legislation like freedom of information or data protection, or TEO's use of Clause 9 would unreasonably duplicate the work of another department, and that department doesn't agree to what TEO had specified. And it's just worth noting there that in terms of data protection, there has been a full data protection impact that had been completed by DFC. The bill is, in the EFM, makes very clear that the power under Clause 9 would not empower TEO to raise money by levying or imposing any form of tax or a charge or by borrowing, but it would not prevent TEO from introducing any reasonable charges for anything that it does under Clause 9. But it does seem that greater clarity would be welcomed regarding the scope of TEO's power in exceptional circumstances in relation to the strategic framework and any strategies that might be published therefrom. So a few questions arise as listed at pages 29 and 30 of the paper.
It's quite just on Clause 9. It's, and this may be a good thing, it's strikingly kind of broadly described, 9.1, where it says, is the Executive Office has power to do anything that it considers appropriate for the purpose of furthering any of the aims, however described in the strategic framework to end violence against women and girls. The power includes power to incur expenditure, give financial assistance, enter into arrangements, cooperate with, provide staff goods. I mean, that's a relatively novel form of words for this kind of legislation?
I wouldn't really be in a position to advise on that. You might want to ask legal that question in particular. It is a very broad power. Clause 10 does qualify to a certain extent, and that's why you would want to learn more about the exceptional circumstances that's envisioned. But in terms of the bill, and as it's currently proposed, there are some scrutiny points that look to seek better understanding about the plans for the implementation of the provision, and therein you may wish to raise some of these questions about the exercise of the power, because it's discretionary as well. Mm-hmm. Yeah, and there's not a lot. It's not peppered with a lot of words like reasonableness. Mm-hmm.
Yeah, it's just strikingly kind of broad, and it's a hugely one of the most important serious issues we face in this society. But it's just understanding the precise import of the legislation is what we're obviously about. So, okay.
But Clause 10 would come into any discussion about that because there is the qualification.
Slightly, yeah.
But it still begs many questions. And I guess that's the reason why in page 29 of the paper at potential scrutiny point 46, you're trying to, the question is geared towards trying to tease out how is this envisioned, the implementation of this power. The other questions there at page 30 of the paper is seeking, again, to just learn a little bit more detail about the exercise of the proposed power. And also the very important point about resources and training, especially when the bill says no financial implications. And there's 3 clauses that talk about further regulations And we don't know what's going to be in those regulations, and 2 of them are proposed to be going by negative resolution. So lots of questions. That's clauses 6, clauses 15, and clauses 17. Clause 6 and clause 17 require negative resolution. Clause 15, there's no specification on the type of resolution required. So if the committee is agreeable, I would propose that at pages 30 through 31, 30 through 30 all the way through to 34, and the clauses within there, 11, 12, 13, and 14. The issues are identified in the paper, but given the interest of time, to move on from them, unless, of course, anybody in the committee has any questions. Is that okay?
Yeah, I'm content to move on a little.
Moving on up to clause 15, then starting at 15.
Jerry had a question on this.
He's 16 and
16,
19.
17.
So those are the clauses that are inclusive 1 to 14 that concern power. So the grouping of power under the bill. So now we're moving on to clauses 15 and 17, page 35 of the pack, and these concern fees. Unless anybody in the committee would like to raise a question, I would say clause 15, there's really nothing particular to note other than there will be regulations brought, and there's no specification as to what type of resolution that will go by. And as a scrutiny committee, the committee would be very interested to know.
This is basically clause 15, which is creates the powers for tourism NI to charge fees.
To introduce new fees where appropriate, and to raise fees for services or events that encourage and improve tourism. And the aim is to safeguard public service provision and improve financial stability in Northern Ireland.
Now, this is interesting because that description from that must come from the EFM, the improving financial sustainability. That is an interesting one because. Sorry, I'm just interested in where the rationale comes about financial sustainability, because that suggests revenue raising. It doesn't. So, you, at first glance, you would think the tourism NI fees are simply about, for example, to go back to the earlier power that they take earlier in the bill to create a rating system. You are a guest house, and in order to register, you have to. You enter into the fee, you pay a fee to register, and then you get yourself adjudicated as 3, 4, 5 star, whatever. That's the fee. But if it's somewhere in a document saying it's about financial sustainability, that would suggest that there's a rationale which is broader and to do with broader fiscal or.
In relation to this second stage, there was reference to financial sustainability.
Where they would need to charge fees.
I said it again, Eileen.
At second stage, there was reference to financial sustainability.
Okay. I think that's.
But it could, if I may, it could beg questions about the outworkings of the financial agreements in February 2024 around sustainability and sustainability.
I think that's the thing we should ask the question about, if there's a desire or what because if it's, I'm keen that we are creative about how we do revenue raising, but at the same time we can't have a situation where we're giving, I'm not saying this is what's happening, but we need to understand whether we're giving a department the power to create a fee with a kind of slightly sotto voce claim that they're using it to improve financial sustainability, when it's sort of not entirely explicit in the face of the bill what that might be. Deputy Chair.
Yeah, thank you, Chair. And I think that it's good to have all of this information on this. I definitely would have a lot of questions in and around this clause, especially given that the tourism NI accounts were, I'm pretty sure they were qualified in 22-23 on fee charging across 3 different schemes, and then it was raised as a matter by exception then in 23-24, and we're still waiting on 24-25 accounts. So just given that there's a number of issues in and around fees with, in particular, tourism NI, I think it's one to look into a bit more detail in terms of committee work around it.
Yeah. So it says, it just seems yeah, I think that's something for us to explore. And as you say, it doesn't make explicit whether any new fees would have to be affirmative, draft affirmative, negative.
It just says that they'll bring regulations, and that the regulations, I would imagine, will speak to that.
Okay. So I think we need to ask questions about what that means. So, yeah, it's in that language there. Okay, yeah, but it doesn't. Yeah, we really need to understand what the read across is in this bill. Okay, go ahead, Eileen. Sorry, that was so it's clause 15. We were on.
So pages 35 to 36. There's a whole series of questions there that the committee may wish to draw on. Clause 16, which concerns marine licensing cost recovery, it basically affords greater power to DARA when charging fees for activities for which a marine license is required, introducing powers to charge for pre-application advice and assistance services, monitoring compliance with the conditions of licensing, and dealing with applications for the variation, suspension, transfer of the licenses. I think it would be interesting, given the way how the power is framed, to learn more about DARA's plans in terms of how it would exercise the new fees. Yep. And then there's a question, would DARA bring regulations and require the Assembly approval under clause 16? And would it be by affirmative or negative?
I'm just going to bring Jerry in now because he did have his questions on this clause.
Yeah,
I'm going to do 16 now, Jerry.
Yeah, thanks, Eileen. Thanks, Chair. Yeah, just on that, I'd agree with a bit more information generally, and thanks for that, Eileen. I mean, as far as you know, is this kind of covering all sort of fishing licensing? Is this sort of commercial fishing, or do you know what level or what extent the department is considering? Because it's quite general, and I'm not quite clear myself.
Yeah, if I may, it would be about asking more questions to ascertain all of that, and what else is within the scope. And also any kind of an assessment for potential costs that would be incurred when providing the additional service for license applicants under 16, and the impact of the charging of the fees and the increased fees for the additional services would have on the number of licenses, license applications in any way. There's a whole series to be unpacked, and on pages 37 through 38, they're listed in full.
Sorry, you made a cover this at the start. Just we're kind of requesting this follow-up information from the departments, or?
All right, say that again, Jerry.
Are we requesting this follow-up information that sort of Eileen's talking about from the departments, or how's that?
I'll let the clerk answer that.
Chair, because we have scrutiny points that are relevant to other committees, what we'll do is once the paper is published, we'll highlight it to them and indicate to them the scrutiny points that are relevant to their clauses within the bill and ask them to pursue those. We have a letter out, we put a letter out in July to the committees that are within the bill, giving them until the end of October to come back to the committee with their views on the clauses. This will help give them a bit of shape to the questions they need to ask. And I think the committee can be reasonably forceful in saying, look, here's the scrutiny points we need answered. So we will seek committee approval once we've been through the paper to do that, if members are content.
Yep, thanks.
Steve, yeah.
Just a very quick, I need to make a declaration of interest. I've been involved in a constituent who's dealing with DARA and the Crown Estates, was specifically relevant to this question, so I just wanted to raise that. And again, just even though I've raised this as a declaration of interest, I think there's a question here about the interrelationship between DARA charging and Crown Estates, and I think that's something that we might ask. That might be a further question, particularly when it comes to seabed and particularly to maritime licensing.
Right, or we suggest that the ERA committee ask that question.
It's quite complex through the chair, but basically, DARA's probably asking to be able to charge for things that it doesn't own, which is not.
It's kind of important that we are, because in certain parts of this we have obviously an overarching scrutiny rule, but for some of the detailed policy stuff, it is still for the individual departmental committees to.
It's a courtesy to them, Chair. However, the committee obviously has overarching responsibility.
Yeah.
So where they're aware, they may want to, the committee may want to pursue the issue.
Yeah, and
Yes.
it also stretches into the Department of Economy as well.
Okay.
Yeah.
And thanks, Jerry. So we'll go on to 17 and then bring Jerry in and get into questions. So I think we're now on clause 17.
This is in relation to the Department for Infrastructure introducing regulations in relation to smart pass fees under the concessionary fare plan, and it's for application renewals as well as replacements. One of the key points in this, we believe, is that regulations will be brought forward by DFI, but there is no, we don't know what the detail is at, and the proposed resolution is negative resolution, and we know that there's a much lower level of scrutiny. And then that recurrent question about resources and funding, resources and training going forward. And it may be helpful to receive some, given the past and recent experiences with TransLink, to maybe seek assurances from DFI and or TransLink about what bodies they'll consult with in relation to those regulations. Would they advise the assembly of responses received, etc., just to tease out how it's envisioned in the plans for the exercise of the Clause 17 power.
Okay, so it's clause 17. So I'd imagine there'll be some questions on this, and I think Jerry did want to come in. So I mean, first of all, it's more, this is again goes back to the questions around interaction between this and budget sustainability discussions, because this introduces the theoretical power to impose a fee for the issue of a smart pass or duplicate smart pass. It's a little bit like some of the conversations we were having in relation to the bill. It is a power that could theoretically allow the this to be introduced, but it doesn't actually say. It says that we by negative resolution, so it wouldn't be there wouldn't be a vote on the floor of the assembly. So just bring in, I think, Jerry, who had indicated first, and then Paul through. Jerry.
Oh, Chair, I just have stated my opposition to this clause before, so if no further questions, I'm going to come in on 19 just after that. Thanks.
Grant. Okay, Paul through.
Yeah, you guys are going to be scrutinising this over a couple of weeks and months anyway.
You can have a go for the next hour.
I won't be there, I'm only in the next hour. But yeah, you might want to look at the negative resolution piece. Draft affirmative would then allow you to at least amend whatever fee that they were subjecting the payment to. And again, we'll need to assess this through our party systems, but the DUP has always been in support of the passes, so again, this is a clause I would worry about. Yep, leave it there.
Okay, so that is clause 17. Mm-hmm. So now clause 18 is basically the consolidated fund.
I'm not sure, did Gemma Dolan have a
Gemma,
question?
no, I don't think so. Gemma, did you want to come in? No?
Apologies, thank you. Okay, so this brings us to the final stretch, the provisions concerning financial governance, clauses 18 to 20. So clause 18 is about increasing the specified 2% cap on the amount of the previous year's authorised expenditure and increasing it to 4%, so that amount instead can be made available to the executive for contingencies during a financial year. Past experience is motivating this to a significant extent. It's about the Northern Ireland Consolidated Fund advances. There's a number of questions that arise from it in relation to clause 18. And most importantly, it begs a question. You'll see there on page 41, we've outlined what occurs in Scotland and Wales in this area. And immediately the question arises, why does Northern Ireland need authority for a higher statutory contingency limit of 4% in relation to the consolidated fund advances when there is a currently 2% level, although our experience has evidence that we are demonstrating that we need more. But in Scotland and Wales, it's 0.5% in both jurisdictions. So the committee may wish to ask the department.
We are asking that that it is increased from 2% to 4%, whereas the equivalent amount for the Scottish government is 0.5, and it always has been. Or are they trying to increase? Sorry, that's probably outside your bill.
The legislation that's highlighted there on page 40 and 41 is dating back to 2000 and 2006, so it's been around for a while. An immediate point that becomes evident is that, you know, we are a post-conflict society. We have different institutional arrangements. We don't have collective responsibility in the way that, for example, the UK government has collective responsibility. Well, you know, that would be the same in Scotland and Wales. But I think it is worth asking the question just based on the other two jurisdictions. It's significantly lower, and we were already higher than them, and we're looking for an increase of 2% again.
Yep. Yeah, Deputy Chair, yeah.
Yeah, and have we an idea of whether they're hitting that limit that they're asking for the increase to?
Apologies, but we haven't looked into that, but we can
do that
bring a
as
paper
committee,
back
yeah,
if the committee wishes.
Just when they're looking to double it from 2% to 4%, you're wondering, you know, are they actually hitting the 2 whenever it's already so high?
Yeah.
Thanks.
Yeah. I mean, yeah. The argument is basically that it's a prudent thing because of COVID, and also the absence of an executive. It seems a bit odd to be baking in additional contingency based on the idea of no executive, but anyway.
Chair, if I
Put that to
may,
one side.
just to clarify what Ms. Forsyth was saying, I understood that you were saying to find out what's happening in the other jurisdictions about whether they hit their limit, or is it in this jurisdiction?
In this jurisdiction, so you're saying we're already at 2% level compared to 0.5 elsewhere, which is quite high, and then it's being asked to double it from 2 to 4. So I was wondering, here in Northern Ireland, are we hitting that 2, and is there actually a need to move it up to 4? That was.
I think there have been incidences, I do understand. COVID was one of them. Now, that was extremely exceptional. However, we can see the pattern and the trend. You could plot that. But would there be value, I would ask, Chair, in looking to what the other jurisdictions are doing and in relation to exercising their power in their jurisdictions, to compare it against the incidents at which we exercise that power under our legislation at 2%?
Yeah.
It would be.
If we can ask that information, Paul.
Just on that, if they're using COVID and the experiences we've had over COVID to raise it from 2 to 4, there's nothing to say that in an emergency scenario that they wouldn't bring in new emergency legislation at that point that would raise this from 2 to 4.
So you're saying why do it now? So the question would be why do it in normal times?
Blanket
I suppose
allowance.
Why have that blanket
Okay. Well, we can ask the question about the specific. I'm trying to remember now. We were on the finance committee whenever. So it would be useful to know if in 2020, for example, they were nudging up against the 2%, and it made it difficult for them to manage, you know, to just do basic financial management at the time when you were doing, for example, all the business grant schemes and obviously the furlough stuff was coming from the UK government. Okay, we can ask those questions. That's really helpful, Eileen. Thank you. So,
Chair, sorry if I may. There's one
Yes.
other point wrapped in that, which you kept on referring to earlier in relation to the budget sustainability and the financial sustainability. So, if we're trying to move towards that, why are we baking in a measure that arguably is not incentivizing financial prudence?
Gives them a lot more latitude.
well, I suppose their argument would be it's a flexibility, but anyway, we will obviously be asking that question. Yeah. Okay. Fair enough.
I like a speed limit, Chair. You drive to the speed limit. It's not
No, you drive just below it, Mr. Frew, being in the Justice Committee.
It becomes a target. So you can imagine civil servants that we had lunch with, all aiming for 4.
Okay. Okay, so clause 19, which is about petroleum and minerals.
There would be nothing of particular note other than what's in the briefing there. It basically is about reducing statutory requirements that exist and streamlining financial reporting of the receipts so that you can support financial governance.
If I'm understanding this correctly, this presumably relates to organisations that are granted licences for things like mining or petroleum production, which you don't really.
It's about the accounts for petroleum and mineral receipts, so,
so
whatever would be within the scope of accountancy purposes.
Basically, so they have to. There are separate accounts for receipts and expenditure, and it's just why not consolidate them into one document, basically. Okay, Jerry.
Yeah, thanks, Seth. So just checking, this will require companies to, instead of providing two copy of accounts, they'll have to provide one copy of account. Is that correct?
This power, from what I read in the clause as well as in the EFM, is about DFE statutory requirements. So it's not speaking to the individual companies. It's speaking to the requirements that DFE must meet in terms of its accounts.
Yeah. No, sorry, I'm just trying to check the document on the screen there was while you're talking. But I think it's reducing the number of accounts required for the companies to provide the DFE or the regulator. Is that correct? I think that's correct.
It would have the knock-on effect, you think, because DFE would be, compiling its accounts on the basis of what they receive in the form of receipts.
And either yourself, Eileen, or through the chair, I just can't recall what the department rationale for that is. So I don't know if we've got.
I think in this one, from my understanding, correct me if I'm wrong, this does seem to be just a tidying up exercise in the sense that they're not trying to publish less information. They're just making it legally. The law basically says it can be in effectively one document or one set of accounts. They still have to publish the same information. So they still have to publish both receipts and expenditure, going in, going out. I'm not actually sure what types of. Well, I presume these are. I don't know whether they're licenses or whatever fees they are, but it's not about what they can levy or don't levy. It's just about the accounts they have to publish and whether they publish two separate accounts rather than one, I think. So I do think this is actually pretty presentational. And
I mean, to the chair and Peter, the clerk, can we just suggest that the economy committee sort of find out what will the difference be? Obviously, there'll be a reduction of accounts, but there'll be potentially less information, which is a bit concerning, but I don't know the detail of that. So maybe if we can suggest the economy committee look at that would be helpful. Yeah,
we can definitely flag them. Although I do think like the memorandum is quite clear. They're not saying less accounts. They're saying publish them in the same document. I think that's what it is. But Diane, who's an accountant,
yeah, Chair, and just to point back into the top of page 173 of the pack and the paper here, like it is saying that this amendment's aiming to streamline the financial reporting and support financial governance. So that's the interpretation through. That was my understanding of it as well, just the reporting.
Okay. Well, we can certainly flag so they're aware of it, and if the economy committee want to investigate. We'll just bring a note.
Yeah, I was just to say, I was just actually having a nosy at the department's annual report, and in cash and cash equivalents, minerals and petroleum receipts are laid out separately and very clearly. So I have no objection to streamlining so that they don't have to have those accounts audited separately, but I would be worried if this change meant that they did not have to present that line in their annual report at all. Question. So just getting clarity that line will still appear, I think, would be helpful.
Those both good points, yeah. Okay. Thanks Jerry, thanks Owen and Diane. Okay, so we're now on to clause 20, which is about how the auditor, not the Comptroller and Auditor General, but the external auditor of the Audit Office is appointed.
And it transfers the current power to the Assembly's Audit Committee. The existing power lay with DOF. does what it says, and in the FM it's also been pointed out that DOF, the Northern Ireland Audit Office, and the Assembly Audit Committee have agreed and seek to action this change.
Yeah. Diane, yeah.
Yeah, thank you, Chair. And to declare just an interest, I'm on the audit committee, and we had met on this morning, and it was the previous audit committee that had agreed that the current audit committee's under consideration, and just to flag, this is, cite it as improving financial governance arrangements. There's practicalities there on how you would actually go about that process, and whether a standing committee of the Assembly has the operational capacity to do some of those things. So just want to flag that here. And Gemma and I were in the audit committee this morning, so whilst it seems tidy and simple in principle, there's a bit more going on there, and I think it'll take a bit of time back and forward between the two committees on that one. It's not straightforward.
And Chair, if I may, at 107 on page 43 of the paper, we do say that you need to be thinking about any new or additional resources that would be required in order to enable its exercise.
Yeah, and the Clerk, we may want to get legal advice on that at some point during our consideration. I think there's clearly a question, but this might seem, I guess, tidy-minded, but it's a fair question to ask whether the audit committee has things like the basic, resource and capacity to run ads and do an appointment process. Assembly committees not being all that, our staff are pretty stretched, but we can ask those questions, because that will have a knock-on impact. Okay, so we've now gone through them all. Are there any other points you want to raise with us? The report is really helpful.
No, thank you.
No. Okay, members, that is obviously going to form part of a considerable part of our consideration of this bill. I think we've already flushed out a few initial issues. Let me just re-summarise now for the purpose of members who just joined us. We just had an initial background briefing from RAISE on their research paper on the report. There are a few specific things which arise, which we are going to flag. Well, in some cases we're going to get more information ourselves directly. In other cases we're going to make a note to flag to the other committees who will be scrutinising this bit of the bill. One of them relates to FTC. I think that's probably something we can tease out in scrutiny. Yep. It relates to FTC in clauses 1 and 2 and why FTC isn't explicitly mentioned.
Next week.
Yeah. Then we also have the question of I think 29A, which also connects to the 15, which is with the Northern Tourist Board. I think it is worth us asking about any intersection between this and discussions on budget sustainability and that strand of budget sustainability work, because if it was said that this was part of, or it was certainly said in the chamber that this was part of broader budget sustainability work, I think we should understand that and what discussions have gone on in the background about, because if the bill is being presented as merely a technical tidying up exercise, but there is in the background an intent, or perhaps maybe there isn't, but the suggestion is that perhaps an intent to create some of the VIRES for certain types for revenue raising, even if it's relatively small scale. I think we do need to understand that, and what discussions have been had, including with, if relevant, with the Treasury. So we could ask that initially with the department. I think we could ask that question. We also there's also in clause 9 a relatively broad question which you just need to tease out in relation to the powers given to the executive office, but then that is somewhat mitigated by the following clause 10. Yeah, clause 10. There is also the question. That goes back to the Tourist Board question, the question around the marine fees, but also the question on the travel concession passes, and if that links in with any of the revenue raising work. I think that is fair enough, and we don't need to ask all these questions now. I don't think we can ask them as they go through, but they're things that occur to us.
Chair, officials will be in next week on both bills, so that would be a good opportunity to pick a bit more into the the basis.
Yeah, and there are a couple of areas where I think we have discovered and flushed out that actually significant changes are coming forward via negative resolution. So we had a prolonged discussion in this committee about powers that were taken in the death, stillbirth and baby loss bill about a theoretical charge ruled out by the department, but would require draft affirmative. So we would, whereas several of the charges potentially in this bill are negative resolutions, so they wouldn't require any further vote. So I think also at least understanding what's intended is going to be very important. So thank you for that.
Thank you.
Thank you, Eileen.
Thank you. Okay, members.
Well done.
I think we actually don't need to.
Paper, Chair.
Yeah, it was very good. Thank you for that. That's an example of great, very pithy, which I think got people us talking and thinking. I'm not sure we need to actually, if we have the officials in front of us next week, it might be worth us raising some of those points with them and then going further if necessary with by Reading. They may well be.
Do you want to send the questions to them in advance, just so they're
If
ready?
they're watching, then
Once
they're
the paper's published, we'll send them the link to it. They will be very aware. Because the data's here, so they'll be very aware of what we know.
So, now, the next agenda item is the motion to extend committee siege. So we're going to go into closed session.